This case might sound like just another DUI sentencing at first glance, but don't let that fool you. What you're about to hear is the slow, painful unraveling of a decade-long pattern that the court has seen again and again and again. The state of Michigan versus Annette Wheeler isn't just about alcohol, it's about accountability, public safety, and what happens when the justice system runs out of second chances. We're talking about 8 prior drunk driving convictions, repeated probation violations, prison time, parole failures, and a defendant who keeps getting back behind the wheel despite knowing exactly what the consequences are. This courtroom becomes the final battleground between compassion and responsibility. On one side, the defense argues trauma, mental health, and treatment. On the other, the prosecution paints a picture of escalating danger of rollovers, extremely high blood alcohol levels, and near misses with tragedy on heavily traveled roads. And standing in the middle of it all is a judge who has clearly had enough. As this sentencing unfolds, pay close attention to the timeline because it tells a story louder than any excuse ever could. The question you should be asking yourself right now is simple: when does empathy stop and public safety begin? Stay with us, because this courtroom doesn't just deliver a sentence, it delivers a reality check.
All right, and our last file today is People of the State of Michigan versus Annette Wheeler. File number today is 25-3644FH. We are here today for sentencing in this case. This case involves a conviction for a drinking and driving third offense, which is a felony, plus there's a second habitual felony offender enhancement. Allocution.
Yeah, this is a very unfortunate situation with Ms. Wheeler. Without question, she has several convictions for operating while intoxicated. However, in meeting with my client most recently, she's come to understand after regularly eating that the underlying issue that she has been not recognizing is the fact that she consumes alcohol as a way to treat issues in her life. She has had severe trauma since a small child. Whenever something major happens in her life, is basically the only time she consumes alcohol, and then she drives and gets arrested. She recognizes she has a severe problem and she needs to address that. So the court's aware. My client attempting to get into a treatment program. She's currently accepted to a program in Saginaw that will address the underlying mental health issue. With that, given our guideline from 7 to 28, I would ask the court to consider release to treatment so that she can address for the first time that she's recognized the fact that her underlying
What you just heard from the defense is a strategy we see often in repeat offense cases, and it's important to break it down clearly. The attorney isn't denying the convictions. In fact, he openly acknowledges them. Instead, he's reframing the behavior as a symptom rather than the core problem. Trauma, untreated mental health issues, and alcohol as a coping mechanism, that's the lens he wants the court to view this through. Legally speaking, this is a request for leniency through treatment, not punishment. He's pointing to sentencing guidelines of 7 to 28 months and asking the judge to exercise discretion by allowing release to an inpatient program instead of incarceration. The argument hinges on one key idea, that this time is different, that the defendant has finally recognized the root cause. But here's the critical question for the court: how many times can someone say, "This time I understand," before the system stops believing it? Especially when public safety is on the line. Keep that in mind, because the prosecution is about to directly challenge whether treatment has already been tried and failed.
Underlying issue is a mental health concern. Thank you.
Mr. Denhouse, on behalf of the people, sir.
Your Honor, the recommendation is for the top of the guidelines, a minimum of 28 months. I would argue that the court has even grounds to exceed that minimum. So I certainly support the recommendation. Unfortunately, nothing has worked with Ms. Wheeler. The last OWI third conviction stemmed from an incident that occurred back in 2023. In that incident, the defendant rolled her vehicle over. It landed on its roof. A very serious incident. The defendant has gone through prior treatment. In fact, from 2016 to 2018, she was in sobriety court. She had just been off of a parole from the last prison sentence for approximately a month. She has 8 prior OWI convictions in the last 11 years. when law enforcement went out there. She was in this incident. She went out to the vehicle. The vehicle was still running, and the test results were exceedingly high, 0.178, 0.179. Also concerning is that she indicated that she wanted to kill herself, which is one thing if an individual wants to kill themselves, which is it's bad enough. I don't want to downplay that by any means, but when they're doing an act that potentially could kill others is also concerning. So clearly a very serious risk to the public. So I fully support the recommendation. And with that, I would ask that the court sentence the defendant.
This is where the tone of the courtroom shifts sharply. The prosecution isn't just responding emotionally, they're laying out a risk assessment. 8 OWI convictions in 11 years. A vehicle rollover. A blood alcohol content nearing 0.18, which is more than twice the legal limit. And perhaps most alarming, suicidal statements made while engaging in behavior that could easily kill innocent people. From a legal standpoint, this argument is powerful because it reframes the case from personal struggle to ongoing danger to the public. The prosecutor emphasizes that treatment has already been attempted, sobriety court, parole, probation, and none of it stopped the behavior. That matters. Courts are not required to keep offering alternatives when those alternatives consistently fail. Here's the uncomfortable truth: when someone repeatedly drives drunk, intent becomes irrelevant. Risk alone is enough. Ask yourself, how many warnings does someone get before the court's duty shifts from rehabilitation to protection?
Sentence the defendant to at least 28 months, Your Honor.
Ms. Wheeler, is there anything you wish to say today?
Your Honor, I'm not very good with this.
It's okay. Take your time.
Your Honor, I failed to admit in the past that I have an alcohol problem and that I have used alcohol for some severe trauma issues that I have gone through since I was age 4. This is not something that I discuss with people. But unfortunately, since I was 50, this is how I've coped. But since being incarcerated this time, I have realized with the help of CMH and CHS that I need psychological treatment for the alcoholism and the severe trauma that I've endured. It has been suggested that I go to the EMDR therapy, and I'm hoping that I have the opportunity to work on that, Your Honor.
This is one of the most human moments in the entire proceeding. The defendant isn't defiant. She isn't dismissive. She's struggling emotionally, physically, mentally. Her statement acknowledges denial, trauma, and long-term coping through alcohol. And when she mentions EMDR therapy, she's referencing a legitimate trauma treatment often used for severe childhood abuse. But here's where courtroom reality sets in: acknowledgement, while important, does not erase consequences. Judges are trained to listen with empathy, but they must sentence with logic. The law doesn't punish feelings, it punishes actions. And in this case, those actions include repeatedly choosing to drive while intoxicated. This moment forces a hard question on everyone watching: can personal pain excuse public danger? Or does responsibility still exist no matter how broken someone feels? The judge is about to answer that, and the answer won't be gentle.
Yeah, Your Honor. Thank you.
Thank you, ma'am. Defendant is 59 years of age. That tells me we have somebody who is old enough and experienced enough to understand making some correct choices. What happens when we make bad choices? There was a report to law enforcement for a be on the lookout for a vehicle being driven by the defendant out on M42, which is one of the most heavily driven roads in Missaukee County. And then over on North Blodgett Road, also another major road in this area. Blood alcohol level here was significantly high at 0.178, and the timing is terrible. The defendant had just been discharged from parole. Well, criminal history began in 2015 with a drinking and driving. That was 10 years ago, so she was approximately 49 years of age. So these crimes have all been combined within about a 10-year period of time. Now, in that particular case, she didn't get probation. She got 45 days of jail and some fines and costs. And it took 1 month later before she got picked up on another charge. I will note that that charge was dismissed. But after it was dismissed, another month later, so we're actually only 2 months out from the sentencing for case one, that she picks up drinking and driving number two. Now, she was charged there with driving license suspended, and while that count was dismissed, I can make a reasonable deduction that because of a drinking and driving, there are some automatic license suspensions. She had no license. Now, thankfully, there she got probation. That probation began on October 14th of 2015. Now, while that case was pending, she violated bond. She makes it 15 days before she violates bond. How does she violate bond? Drinking and driving. I'm curious as to what major events are all happening back to back to back where she can't stay off of the booze. Regardless of what they are, all I am learning is that you can't make good decisions. It's your third drinking and driving within 4 months, 5 months, you get probation on 2 files. You were on that probation from October of 2015, and you make it 7 months before you violated it. Then there was another issue. In fact, you even got 15 days in jail. When those 15 days were done, you got another bench warrant, and you had to be sentenced again. Within 8 months of being on probation, you violated it twice. You can't comply with bond, you can't comply with probation, and you can't comply with the laws that say don't drive a car. Now, here in this case, you were convicted on March 28th of 2016. You made it 3 weeks for violating probation again and picking up your third drinking and driving. And it looks like you were placed on a delay of sentence and given the opportunity to sobriety court, yet you struggled with it. They said you successfully completed the program. I don't know how, based upon what I'm seeing in here, but they gave you a completion of the program. Well, if you completed it on July of 2018, you made it 11 months. So far, that's the longest you had made it in the last 3-4 years. You made it 11 months before you picked up your next drinking and driving. So I think right now we're on number 4.
What the judge is doing here is something incredibly deliberate and devastatingly effective. He's walking through the defendant's entire criminal timeline, step by step, offense by offense. This isn't about one bad night. This is about a repeated cycle: arrest, probation, violation, arrest again. Over and over. Legally, this matters because sentencing isn't just based on the current charge, it's based on patterns of behavior. And the pattern here shows escalating risk, repeated non-compliance, and a complete disregard for court orders. The judge points out probation violations within weeks. Early discharges followed by immediate reoffending. Sobriety court followed by relapse. This isn't sarcasm, it's frustration backed by facts. And when a judge starts laying things out this methodically, it's usually a sign that leniency is off the table. The message is clear: the court has tried everything else.
And this results in a plea and a conviction. You get probation, and you did receive an early discharge from probation. You were compliant. One moment. Yeah, so you got an early discharge from your probation, and you celebrated with picking up your next drinking and driving a few months later. Plus, you're driving a car when you have no license. You should never, ever drive a car. I don't know how you're getting access to cars. I don't know who is letting you have the keys. I would wonder if these cars are licensed. Do they have insurance? It's funny because if you're out paying for insurance and paying for registration on your own vehicle, that's crazy. But if you're taking someone else's vehicle, I want to know how'd you get their vehicle. You should never, ever drive a vehicle. Your days of driving for the rest of your life are most likely, because I'm not in charge of licenses, the Secretary of State is, you should never, ever have a car in your name and never ever touched the steering wheel. All right, so 6 months later, now we're in October 2021. You pick up your next drink and driving. You've even got alcohol opened in the vehicle while you're driving. The probation was terminated by me unsuccessfully. Then after that, I'm sorry, while you're on that probation, and I terminated you unsuccessfully because you only made it 9 months before you picked up your next drinking and driving. You pled no contest. I have to that would have been because of how drunk you were. Then I gave you prison, 18 to 60 months in the Department of Corrections. You get out, you get parole, you're discharged from parole. 34 days later, drinking and conviction number 8. It assesses a $68 state minimum fee, a $130 crime victims' rights fund fee, a $300 court cost. I don't need to do a DNA fee, a $300 attorney fee. Now I'm going to go back for a moment here. And I don't typically do this, not a lot of people pay the fines and costs and stuff. And there's a lot of philosophies or theories out there from other judges about, well, do they pay them or not pay them? Do they still get put on parole? I'm going to tell you, if you're able to drive a car and somehow pay or have access to a car, I think you can pay your bills. I'm going to assess a $1,500 fine. Supervision fees? No, because we're not doing any probation. That's for certain. This court sentences the defendant to a prison term of 28 to 90 months. I exercise the discretion to sentence her as a second habitual felony offender. And the court gives her 106 days.
This is the turning point. The sentence, 28 to 90 months in prison, reflects both the guideline maximum and the habitual offender enhancement. This is not symbolic punishment. This is incapacitation. The court is explicitly saying that supervision in the community has failed and that prison is now the only option left. The financial penalties matter too. Fines, costs, deadlines, and consequences for non-payment are all tied directly to parole conditions. This isn't just about serving time, it's about accountability on every level. And when the judge addresses the defendant's attitude, he's highlighting something critical: mindset matters. Courts don't just evaluate actions, they evaluate whether someone is capable of change. At this moment, the judge isn't angry. He's resolved. And that distinction makes all the difference.
106 days of credit. This is not like a case where somebody gets one, does a probation, tries, goes to some AA, does stuff. This is a person that might get 3. This is 8 drinking and driving. It is now prison time for you, and that seems to be where you want to go. All right. I'll correct it with the clerk, but the fines and costs must be paid within 56 days, or there's a 20% penalty that is added. The court will also make paying them a term or condition of your parole. Now, I heard you say a little while ago, Ms. Wheeler, that while I was talking, and that's okay, you didn't like it, you interrupt me loudly. You said you couldn't take this or couldn't do this. Rid of that attitude. That's the attitude that causes a person like you who knows well enough to go, I can't take the stresses of my life. I'm going to booze it up, get drunk, get in a car, and put people at danger because I can't take the stress. Now, yes, I'm being a little sarcastic with my tone there. Ms. Wheeler, you are the only person who can deal with it. You can't. It's like me, people like me in this position are just going to keep putting you in prison. And I bet you've got people out there that love you and care about you. I also bet, because I am, family members, alcoholics, we all know that alcoholics are the best liars. And they self-pity. Don't do that. They love you. That doesn't mean you're a rotten, none of this means you're a rotten person or that you're worthless, anything like that. They love you. They're here for you. We all want you to get better. You got a lot of life to live. 59 is not that old anymore.
This case ends where many repeat offense cases eventually do, with the court choosing public safety over hope. The judge acknowledged trauma, addiction, and humanity, but ultimately ruled based on a decade of evidence showing repeated failure to comply with the law. The final sentence reflects not just punishment, but exhaustion from a system that gave chance after chance and saw the same outcome every time. The takeaway here is clear: rehabilitation only works when behavior changes. And when it doesn't, the court's responsibility shifts. This ruling sends a strong message about accountability, consequences, and the limits of judicial patience. Now we want to hear from you. Was this sentence fair, or should treatment have been tried one last time? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.